Like I said in the past, I'm going to simplify things. So um, yeah, that is how I'm gonna choose to um, do things from now on. Okay, so this is a video for those who has never dealt with any type of a dispute before. But you're in the workplace and you feel that there's something happening in the workplace where you feel disrespected. You feel maybe your employer is treating you badly or unfairly, but you don't quite know what to do about it. Um, well, this video is for you, basically, so that you can be able to know what to expect and what to do. So let's say now you have been you've been charged for misconduct. You've done something wrong, whatever the case may be. But you know for a fact, but I feel I'm being targeted. I don't know why this is happening to me. I don't even know what to do. Okay, then the first thing you need to know is, but so before I started, basically there is 4 steps that you need to know in relation to a dispute and what you should be able to do when you find yourself in that position. So basically, the first thing you have to do is you need to recognize that this is a dispute. So I'm of the view that I am not wrong, and the employer is charging me for something that I did wrong. So which means you at loggerheads now, you having opposing views on the situation. So what must happen then? There must be some kind of mechanism where you are able to find a solution to this dispute, because I mean it's not good for this for to continue for long periods of time in the workplace, because what will happen now is that you will be unhappy and you won't be productive, and this is an all spiraling ripple effect when it comes to that. So in essence, you want this thing to be resolved. Okay, so what's the first thing you find out now? Okay, in my company there must be an HR. HR is in traditionally supposed to be a neutral place where you are able to just go to HR and say, "This is my problem that I have. What steps can I take? Whatever problem you have, they will then are the people that's supposed to be helping you." So then, most likely, they will have an internal dispute resolution mechanism that will deal with it. So then, that is step one. So you know there's a dispute, and the company must do something about it. You need to know what's going to happen in relation to this issue that I'm faced with. Naturally, there is a internal disciplinary inquiry that will take place, because now you're being charged. There's something that happened. That is basically step one. I found this in the Labor Relations Act. There's a flow diagram in the Labor Relations Act that I'm going to put up on the screen. So basically, you're going to follow what that says and follow in terms of what I'm going to say. I'm going to go through it. And basically, there's 4 steps that you need to know in relation to that. So now that the internal dispute resolution mechanism has now obviously failed, and maybe they still feel find you guilty, and you feel that they perhaps were biased against you. Well, there is still hope for you. Then that the internal resolution mechanism has been, what is the word I'm looking for now? Has been exhausted now. Yes, it has been exhausted. So you go to the external dispute resolution mechanism, and that body is called the CCMA, the Commission for Conciliation, Mediation, Arbitration. Okay, you can have a look at them, perhaps what they do. It's a tribunal that deal with disputes, and more specifically labor disputes. There's other places that deal with other type of disputes. What happens at the CCMA? Okay, the first thing you need to do is you need to fill in a form. It's called a 7.11 form. I'm gonna put it up there for you to be able to see. You fill it in. The form basically explains what is the nature of dispute, when did it happen. There's a whole bunch of self-explanatory questions that you can follow in that form, and then once that is now done, the next step, the most important step, which is now we move on to step number 2, is where you go to the external dispute resolution body. And step number 2 is you are going to file a complaint against your employer at the CCMA. Now, what does that mean? Because obviously you couldn't find recourse at the company. Then now the form will tell you, give me the employer's details. What is your details? What's the nature of the dispute, like I said? And then what will happen is the CCMA now is going to summon your employer to come to the CCMA and say, look, there's a dispute. Nandi has lost the dispute against you. against XYZ Industries. So XY, it's going to be Nandi versus XYZ Industry as an example, just to make an example about that. So now you ventured into step number two. Then now you're not going to do anything now. The CCMA is going to do this on your behalf, where they're going to call your employer and send them an email. They're going to notify them, and that is called a set down notice. It's just law terms, but I mean, it just means that there's going to be a time where you as the employee go to the CCMA, and the employer go to the CCMA, and then the CCMA will appoint a commissioner to try to facilitate um, a way forward in terms of settling this dispute that you have. Okay, so now this ties into also step number two. There will be called a conciliation process, where now you'll see what happens. What is a conciliation? Sounds so complicated, but it's not that it just basically means that it's an informal process where you now are actually going to the commissioner is going to ask you, how can we solve this problem? Was there perhaps something where you guys have a miscommunication about things, or and then hopefully the matter can be settled at conciliation, where the commissioner will facilitate the dispute and try to find common ground. And then once that is successful, you will enter what's called a settlement agreement, where the commissioner will outline the points, give the remedy in the settlement agreement, and then both parties will sign, and that will be the end of the dispute. This dispute has been dealt with, it's been disposed of, nothing will happen. And also, just to mention, this conciliation is enshrined in the Labor Relations Act. These things are just not like plucked from the air. All these things that I'm mentioning is legislated, you know, because even before you come to the CCMA, they will ask you, have you had any form of try to resolve the dispute internally? Then you'll say, okay, yes, Commissioner, this was what happened at the company. I had a grievance. The grievance was not dealt with, and it's still unresolved. Or I've been charged, and this is the outcome. This is the dispute resolution outcome. I've been found guilty in my disciplinary hearing, and this is the charge sheet. So those are the type of, just an example. I'm just going from the top of my head now in terms of some of the things that can take place. Okay, then fine. Then Section 135 of the Labor Relations Act comes into effect, and you guys can read what that is all about. I'm not going to explain. But by the way, you can just see these things are also highlighted in the flow diagram that is on the screen there. And another important thing to remember is you have 30 days from the date of the dispute up until you go to the CCMA. You have 30 days to do that. After that, you will go into condemnation process. You don't really want that, because that is a process whereby now you will have to explain before the case even starts, why were you late, and you must have valid reason. You must make an application for that. So to avoid that, just remember that you have to refer this thing within 30 days. So now remember, we're still by step number two. There's two more steps. So basically, we're halfway through. Like I explained, the final thing is a settlement agreement. Okay, let's say it's now not settled. The next step is now the formal process must take place now. But before that, you need to get something what is called, wait, I'm just going to show you. I have something to show you, a physical thing, a practical demonstration of something that you will need to refer your case to the CCMA. But just hold 1 second. Uh, I think yes, I'm good to go. Okay, so after this dispute is now has now been dealt with in terms of conciliation, this is a actual certificate of outcome of somebody that has already finished the stage of conciliation. Okay, so without this document, you can't refer the matter to step number 3, which is the arbitration. So then now the commissioner will say, like, okay, this case is now not resolved. um, you can now refer to arbitration. Then we go to step number 3 now. Step number 3 is very important. This is now informal. This is now not informal. Sorry, this is a formal process now where evidence need to be laid before the commissioner in terms of who's wrong and who's right. You see, there's issues of you can call witnesses. You can bring bundles of documents to prove your case. You can testify. And then there will be a cross-examination, re-examination. Of course, if you want me to, I can cover those things. Basically, everything that I've been spoken is that I've been speaking about now. It's just a brief overview. I can go into detail in terms of each and every step, but for the purposes of you learning for the first time, I'm just giving you like in a in the most simplistic way in terms of how to deal with how to deal with the dispute as you go through the phases, right? So now we're by phase number 3. Then now you'll have to request for arbitration. How do you do that? You need a certificate of outcome, like I said, and that is step number 3. It's called an arbitration process, like I said, and that is informed in terms of section 136 of the Labor Relations Act. And in that process, you have now 90 days to refer your dispute to the CCMA. I'm not sure why is the one 30 days and the other one 90 days. It seems a bit disjointed, but that's how it has always been. But I suspect the reason for that is because before you refer your matter to arbitration, you'll get all your documents ready. You'll ask people to come and testify in your hearing. You will get the documents from the employer to create your bundle of evidence. You'll prepare with the person that's going to represent you. So you in conciliation, there's no need for representation. It's actually not allowed. It's just informal. But in arbitration, you could even appoint your attorney to represent you at the CCMA. You know, because this is now a formal process. Now it's almost like a mini court hearing where we need to get the evidence in terms of for the commissioner to apply his mind to determine who is wrong, who's right. That is the arbitration one. That is a complex, a detailed situation that happens there. But perhaps I will cover that if people want me to in detail and as to how conduct yourself in an arbitration process. And then finally, in conclusion, you get the CCMA award that the commissioner will give you, and he has 14 days to to tender you with the arbitration award, and that is basically the outcome of as to what transpired, and he will say who's wrong and who's right. You see, so, there's details in with regard to that as well when it comes to the award in terms of what relief do you seek, what do you want, perhaps if you were dismissed reinstatement, or if you were unfairly treated, do you want compensation? There's those type of things as well that is in the arbitration. Now, step number 3 is concluded. The arbitration process has been ventilated, and now step number 4 is the arbitration award. And then what will happen there is that the commissioner has 14 days to give his outcome of his verdict in terms of the case, because he applied his mind now, he listened to both sides of the story, and in 14 days you'll get an arbitration award. And that is basically where the CCMA stops in terms of their role with the arbitration award. If you are still not happy with the arbitration award, then you can appoint an attorney to have the matter taken on review. In essence, what it means, you are able to take the CCMA arbitration award on review, and the only place you can do this no longer at the CCMA, it's at the labor court, and that takes a long time. There's no time frames in relation to that. It's subject to the availability of dates to when your case can be heard. It takes a very long time. I think it's a little bit this juncture there between the CCMA and the labor court when it comes to disputes. It can take up until anywhere between a year to 3 years before this case can be heard, and it can be postponed and so on and so forth. So yeah, that's just basically what I wanted to say in relation to a dispute. Just if you have any further questions, don't forget to like and subscribe to the channel, and I'll catch you guys in the next one. Remember, with me, you're going to learn. Thank you very much.